Greetings. Let's see. I better adjust that some other way, maybe. There it goes. 1760 perjury case, 28 USC 1746. Unsworn declaration under penalty of perjury. Wherever under any law of the United States or under any rule, regulation, order, or requirement made pursuant to law, any matter is required or permitted to be supported, evidenced, established, or proved by the sworn declaration, verification, certificate, statement, oath, or affidavit, in writing of the person making the same, other than a deposition or an oath of office or an oath required to be taken before a specified official other than a notary public. Such matter may, with like force and effect, be supported, evidenced, established, or proven by the unsworn declaration, certificate, verification, or statement in writing of such person, which is subscribed by him, as true under penalty of perjury and dated in the substantially the following form. Ladies and gentlemen, they're going to show you how to do it. All right? The importance of opening up these books and reading. If executed without the United States, I declare, or certify, verify, or state under penalty of perjury under the laws of the United States of America that the foregoing is true and correct, executed on date followed by your autograph. If executed within the United States, its territories, possessions, or commonwealths, indicating still part of Britain, Commonwealth, all right? The United States is Europe. That's the flag they fly, red, white, and blue, baby. I declare, or certify, verify, or state under the penalty of perjury that the foregoing is true and correct, executed on the date, followed by the signature. It's cited in USAM 9-69.200. Very, very important. The distinctions that we see here. If executed without the United States, right here, okay, and if executed within the United States, and if it's executed without the United States, but within the United States of America, okay, the foregoing being true and correct with your autograph. It's about knowing who you are. It's about knowing the history of this great land, and furthermore, the world history, to comprehend what that good book, that Bible, tells you. All right? Title 28 USC Code subsection 1746, unsworn declarations under the penalty of perjury, whoever or wherever under any law of the United States, under any rule, regulation, order, or requirement made pursuant to law, any matter is required or permitted to be supported, evidenced, established, or proved by the sworn declaration, verification, certification, certificate, statements, oath, or affidavit in writing of the person making the same. That's you. So in Title 28 USC 1746, 1, I don't know if this is you or not. You have to make the decision. You have to make the assertion of where you're at, where your domicile's at. I know where my domicile's at. Where's yours? I don't have an address. I have a location. One doesn't have a name. It's a Christian appellation. It's all about, do you know who you are? Do you know where you stand? Are you on the land or are you in legal land? You know, there's two different places you can be. You can be in legal land or you can be on the land. And the choice is really yours. And everything that they're doing, they have the ability to do because we have the ability to contract at will, and we also have the ability not to contract at will. The government ended up creating another entity and decided to do business underneath that entity. And if you have the right under Article 1, or the right that is protected under Article 1, Section 10, which is to create unlimited contracts and to contract at will, then all corporations have the same substantial right protected under Article 1, subsection 10. It's just business. And you can either participate with them or not participate with them. But you have to know who you are in order to make that distinction and create that separation. Because it's the contracts that they're holding you to. Debtors' prisons are illegal. You cannot go to prison for a debt. And people go, well, Derek, there's people going to jail all the time for child support. You're entered into a contract. Rescind your signature. Revoke your signature. Revoke your consent. Take it back. And abolish the contract. That's simple. Get rid of it. Abolish it. You show me the two parties that entered into the contract that had full disclosure and full understanding of the contract they were entering into, and that there were no blind adhesion contracts or due process violations. Show me the wedding signature of two parties on the same document that agreed to this contract that you're holding me to. Where is it? How was this debt created? In what instance was there authority from the author, which would have been me, granting you the authority to create such a nuisance and problem? United States, Title 28, U.S.C., subsection 3002-15. United States means A, federal corporation, B, agency, department, commission, board, or other entity of the United States, or C, an instrumentality of the United States. Ladies and gentlemen, it's in their writs. All you have to do is read. He who has the eyes to see, let him see. He who has the ears to hear, let him hear. But there's also a maximum of law that goes, and I'll paraphrase this. It's something to the effect that let he who wishes to be ignorant remain ignorant. Okay? I'm not here to beat this into your head. I'm not here to hold your hand through the whole process. I'm here to show you some stuff that's extraordinarily valuable. Required knowledge, people. This is most important post ever. This was made by a man by the name of, or by the calling of John, and super sharp guy, John Lacron. And for those of you guys that don't have him on Facebook, add him on Facebook, follow him. I'm sure he's well over 5,000 friends. He shares some very, very awesome knowledge. I don't agree with everything, but there's a lot in here that is so powerful and a great place for beginners to start their research into figuring out who they are. So I'm going to read this to you guys. It's pretty lengthy, but ultimately, in the end, it benefits each and every one of you to share this video with your friends and your family. Everything in this universe always comes full circle, and it has done so for me ahead of schedule. Everyone has an origin, and this is an important part of mine. My journey with discovering the depravity of the fraud started in a small town of Bear Lake, Michigan, several years ago. It was compounded a few years ago which started me on my journey of learning the depths of the depravity of the bar mafia and the criminal corporate entities and employees calling themselves government. This, ladies and gentlemen, is my first gift to each of you. Use it as you see fit. Send me positive vibes as battling crime syndicates on Friday the 14th, Valentine's Day. Needless to say, I don't think they are going to love me. Evil grin. Public judicial and constructive notice and claims for case number 19-16797-C7. The Honorable John McCotter Lacron, apologize if I'm saying that incorrectly, acting as the claimant, executor, and beneficiary, a living man with status and standing on the land and not lost at sea or dead, retains all unalienable rights and waives none, whether statutory or procedural. All presumptions without evidence are rebutted, and he now establishes his common law court of record, Article 3, court where the magistrate trustee is separate from the tribunal, and all actions involve only men and women under oath or affirmation of facts filed under the pains and penalties of perjury. Uh-oh. Uh-oh. There's some big problems right there for these actors. He's calling them to their oath. He's accepting their oath of office, and he's going to hold them to it. He's going to force them to put their credits on account where their mouth is, and they better watch what they do. No corporation, fiction, person have status or standing, jurisdiction, or original moving court is challenged and moved for cause. He's exposing the shenanigans, and he's taking control of the court. And he's now holding his court that's going to conduct an investigation into the legitimacy of what their court, which is a private court, a private bar mafia court, that they're using to fleece you and extort you through securities, bonds, and a number of other instruments. It's all a financial ruckus. That causes being a failure of full disclosure, mutual consideration, a meeting of the minds, and 2 wet ink signatures or autographs of a legitimate contract. That's biblical, ladies and gentlemen. There shall always be 2 witnesses at any time you enter into a contract, that witness 2 parties enter into that contract for it to be a valid binding contract. There always must be an ascension of the mind. It's in the Bible. It's biblical. Offer and acceptance do not constitute a valid contract when it is for the purpose of exploitation. Officer on the side of the road issuing a securities instrument where he alleges the state is a party to the instrument, but at the same time, you haven't met with the state, you haven't had a chance to have an ascension of the mind with the state, and furthermore, you are the only party of interest on that instrument. You are the only one that brought life to it of any value or substance with your autograph. That securities instrument is your securities instrument that belongs in your trust, for which you are the beneficiary of. If you're a trustee of that estate, then you're due an owing for working that estate, because everybody is due their fair share, because no man works for free. Involuntary servitude is illegal. So if you're managing that estate, you have a right to be compensated for your efforts. This is especially true when key issues are deliberately hidden under the color of language and color of law by bar members and trustees. Remember Luke 11:45, woe unto ye lawyers, for you hold the key of knowledge, yet you touch the burdens not with one of your own fingers, yet hinder the men who would willfully walk in from doing so. The trustee with the black robe acting as judge is held to the oath of office, whether that oath is on file on the public record or not. A violation of oath is a federal crime pursuant to Title 5 USC Section 7311 and Executive Order 10,450. Executive order is powerful here. And the reason it's powerful is because we've been in time of martial law since the Civil War, and quite possibly even before that. But the Civil War for absolute certainty. And so because of that, the president for the corporation identified as the United States under Title 28, 3002, 15A, has the authority at any time during this national emergency, the state of national emergency, to override Congress, the Senate, the House of Representatives, because he's the commander-in-chief of the greatest military force in the world, and because of the time of the national emergency, his executive orders are just as powerful as the Pope's. The Pope can create law with the stroke of a pen, and he needs no other man to help him push it through. So executive orders are important. They identify what condition the United States corporation is in, which is a position of insolvency. They have nothing. They're bankrupt. They're broke. Punishment may include removal from office, prisons, and fines. Misprison of a felony is also of concern to claimant. See Title 18, Section 4. The cloak of sovereign immunity is lost through criminal actions and abuse of discretion. Claimant expects and is entitled to honor service by the public trustees acting as judge whose corporation is listed on the Duns and Bradstreet. He's pointing out the fact that it's business, that they're just doing business. So if the business and the trustees cause conflict, harm, injury, damage, and loss to the man, who's going to indemnify him? Okay, we've got to make sure that the claimant in this scenario, John, is protected. If this corporation and its trustees shall cause him as a man harm where there is no crime, okay, or valid contract, who's going to make him whole? No policy enforcement officer or agent of a corporate government may testify unless they take oath as a man or a woman and not as a corporate employee, person, or nom de guerre, name of war, because the United States, North American continent, is a battlefield, ladies and gentlemen. And claimant does not accept titles. Refer to claimant only as claimant or John. A corporation fiction person cannot be plaintiff or claimant, as it has no status or standing and cannot be held accountable under the pains and penalties of perjury. Why? It doesn't have a soul, it doesn't have a spirit, it doesn't have a body, it doesn't have a pulse. I could go on. I'll digress. Nor can something imaginary be cross-examined. No attorney may represent a decedent, as they are incompetent to testify under Rule 601 of the Federal Rules of Evidence and the Dead Man's Statutes. Also, claimant does not consent to joinder between the living man and the corporate fiction person, the Sestake v. Trust, the Sestake v. Latin for proof of life. Trust, although claimant will retain his right to access that trust for remedy, as it was created for claimant's benefit. Okay, claimant is hereby special appearance. So there's a general appearance, a special appearance. You got general deposit and special deposit. I encourage you guys to go write this down and go look it up. Special appearance, and then you have a general appearance, or just an appearance. Then you have special deposit, you have special posit, you have a general deposit or a general posit. Under threat and duress, and does not waive any rights, remedies, or defense, whether statutory or procedural. Claimant does not consent to the abduction and storage of himself to be the surety. We're in trust law here, ladies and gentlemen. He's not going to be the surety for the debtor corporation, for a corporation debt, for corporation's debts. Claimant retains all of his unalienable rights and requires prosecutor to prove all 7 elements of jurisdiction. The agents of the bar and the various corporations masquerading as governments, Latin origin meaning mind control, have caused and are continuing to cause claimant injury and harm under threat and duress. Claimant requires the clerk trustee magistrate oath of office and is holding the magistrate to that oath of office and to the position of public trustee. In addition, claimant requires the magistrate and original moving party prosecutor's bonds who originally created this controversy, as well as the name of the issuer and telephone number for the same. Claimant is not a ward of the state and is capable of handling his own affairs, so no perennis parte relationship exists. Claimant retains his position as creditor, beneficiary, and attorney in fact. All contracts are to be clearly articulated and entered into the record, and no hidden contracts are permitted. Contracts must have all required elements to be valid, to include full disclosure, a meeting of the minds, mutual consideration, and wedding signature or autograph of both contracting parties. He's expressing the trust. Pay attention. All presumptions are rebutted. Judicial discretion is not granted. Claimant expects honest service. Claimant also requires the letter of marque and reprisal and discovery to include findings of facts and conclusions of law. Claimant retains his in personam jurisdiction and his in rem jurisdiction. Claimant does not consent to the crimes of hypothecation, personages, bartery, abduction, hostage-taking, human trafficking, coercion, practicing law from the bench, fraudulent conveyance of language, assault, battery, kidnapping, extortion, racketeering, on-land piracy, criminal conversion, malice prosecution, bills of attainder, jury tampering, peonage, press ganging, usufruct, or any other common law crimes against the man or the man's person, as these are all a trespass against the claimant. Claimant is not bound by legalese, dog Latin, glossa, words of art, word art, or syntax grammar, acts, statutes, codes, rules, regulations, the Administrative Procedures Act of June 11, 1946, Public Law 79-404, 60 Stat 237. Or the Unidroit Treaty are all foreign to claimant. Claimant does not answer to imaginary fictions or their self-appointed corporate agents with bar cards or privateers with costumes, badges, and guns. Claimant is not chattel property, a transmitting utility, Roman Catholic, a British or Vatican subject, employee of the state of Tennessee or state of Michigan, corporation, or the United States. Corporation. Title 28, USC 3002, Section 15A. Or the city of Clarksville Municipal Corporation, or the county of Montgomery, or the village of Bear Lake, or Manistee County. Claimant is not a Cesta KV trust, vessel, lost or misplaced cargo, person, corporation, ship, dead body, or slave. Claimant is entitled to full disclosure as well as to subrogation. Claimant requires the public trustee to be unbiased and to discharge this color of law matter as claimant is claiming the property. It is corporate public policy that all crimes are commercial. Title 27 CFR 72 period 11, and that no debts can be paid, only discharged. March 9th, 1933, Bankruptcy House Joint Resolution codified in 192. Claimant revokes all contracts based on maritime admiralty, constructive contract fraud, and racketeering as they do not have full disclosure or a meeting of the minds or mutual consideration and are void from the beginning for cause. Claimant does not delegate his authority to anyone. Claimant's unalienable rights have been converted into privileges under the color of law, which is a crime. Failure to provide remedy is both dishonorable and actionable. Claimant's very expensive fee schedule is on the public record for those who wish to trespass against him. Claimant is fully prepared to settle this matter on the private side. Notice how he's not arguing any facts or would-be facts of the case. Because there's no controversy, it's basically a conditional acceptance. But more so, he's compelling the trustee to act in their fiduciary capacity to set off the alleged claim or value that has been created and generated in his good name. And I haven't read this, so this is the first time I'm going through this. But he also has the power to compel to make sure that the books are balanced and that all rights, titles, interest, baggage, and res are returned to the original source issuer, which would be him, the signature, which is what the value is. So that's something to think about. And I'm not sure he may cover that in this. All actions based on fraud are void from the beginning. This maximum of law has been around for centuries. Now regarding the fraud, here are additional examples which can prove claimant, but they're proven by claimant, but there are many more. All of these corporations masquerading as de facto governments are bankrupt. Using the crimes of personage and battery, they have enslaved the people in their communities and turned them into debt slaves for these foreign banking interests. The people have been press-ganged into serving these corporations using threat and duress. Fraudulent conveyance of language through the use of words with meanings that are different than that in the common use. Unliteral contracts are created for the purpose of pillaging people and their property and trusts. This is a mixed war between the corporation agents and the people who are victims behind plundered, or are the victims being plundered. Corporations and governments are nothing more than trusts created for the benefit of the owners of the trust These corporations, through their agents and employees, have stolen the sovereignty of the people and then granted to themselves rights to plunder under the color of law. This is unlawful and immoral. Capitis diminuitio maxima means maximum loss of status in Latin. The people have been turned into surety for these corporations, debts, and the use of all capital letter names, such as John Larkin, are how people's rights are stolen. There are only 5 things an all capital letter name can be, and they are: the name of a ship, the name of a corporation, a dead body, a slave, title to a Sesta KV trust. In these kangaroo courts, the people are looked at as being all 5, as they are being administered for profit by agents of the bar. The cloak of sovereign immunity is lost through criminal action and abuse of discretion by those employed by these corporations. For far too long, sovereign immunity has been used to commit a multitude of crimes. Below is a list of many of the crimes and trespasses, but it is in no way complete. Self-interested deceit, fraud, constructive fraud, malfeasance, misfeasance, nonfeasance, felony breach of trust, threat and duress, terrorism, unlawful conversion, threat by unlawful taking or disposition, breach of international treaties, war privateering, press ganging, inland piracy, enslavement, peonage, conscription under force, racketeering, usurpation, identity theft, false imprisonment, extortion under color of law, extortion under threat and duress, human trafficking, heinous crimes, armed robbery, accessories to armed robbery, kidnapping, aggravated kidnapping, U.S. mail to extort, fraudulent conveyance of language, reckless indifference resulting in mental anguish, bringing private law into the public, emotional abuse, abuse of office, malicious prosecution, prosecutorial misconduct, unlawfully claiming power of attorney, personage, bartery, refusal to address valid claims, commercial feudalism, fraudulent contracting, violation of Homestead Act, reckless endangerment, stalking, harassment, kidnapping, held for ransom, using contract law when people are owed a common law court of record, bringing false complaints for a fictitious plaintiff, treason against lawful government, breach of peace, conspiracy against rights, domestic terrorism, using a bill of attainder. The bar is a closed union shop, so forcing people to only have counsel that are members of the bar is a monopoly, which is highly illegal. Violation of judicial canons, failure to produce a public hazard bond, violation of due process, murder, manslaughter, deprivation of rights under color of law, practicing law from the bench, lying under oath, having no oath of office, breach of oath, false arrest or warrantless arrest, drug trafficking, chemical warfare via vaccines, chemtrails and fluoride, also pepper spray, the number of different gases they use. It's all highly illegal and a trespass against humanity. Breaking and entering, trespassing, assault with a deadly weapon, jury tampering, witness tampering, presumptions with no evidence, bribery, semantic deceit, violation of Titles of Nobility Act, intrinsic fraud, fraud upon the court, fraud of the process, usufruct, intrinsic fraud, slander, libel, defamation of character, alienation of affection, fraudulent concealment, prejudice, hearsay evidence permitted, assume facts not in evidence, official oppression, and all of these are objections in the court you can make, by the way. Objection, defamation of character, objection, alienation of affection, objection, concealment, objection, prejudice, objection, hearsay evidence not permitted, objection, assume facts not in evidence. Want it noted for the record. I need finding of facts, conclusions of law, objection, official oppression, objection, aggravated perjury. You can point these things out. Misappropriation of public funds, using petit juries. Practicing law without license. Bar cards are union dues cards given by private association. Abusive prosecutorial discretion. Ex parte, talking to the judge alone about the case before the case is heard, which is illegal. Inability to void or audio record court cases where crimes are committed. Bribery, kickbacks, conspiracy to defraud, misuse of alter ego, unbonded summary process, prison bonds, court cases get QSIP numbers, criminal possession of a fraud instrument, a forged instrument, intimidating a participant in a legal process, contempt of court, retaliating against participants in legal process, contempt of court, criminal mischief, receiving stolen property, criminal conspiracy, wanton engagement, tampering with physical evidence, complicity, knowingly exploit adult by person, fraudulent use of social security number, legal abuse, discrimination, denial of due process, tax evasion, abuse of plenary powers, invasion of privacy, conflict of interest, practicing medicine without a license when holding someone unlawfully for a competency assessment, impersonating a public servant, forcing counsel to a member of the bar, entrapment, emolument, salary, and fees from employment or office, collection of unlawful debts, violations of Libra Code, respecting of persons, unconscionable contracts. The benefits to being a free-range tax slave are minuscule for most people who would rather be free if told the truth and given the choice. A complaint is not a lawful claim filed under the pains and penalty of perjury. Legal tender does not lawfully discharge debts. There must be value given for value. Claimant in possession of property has standing as it is his equity and his property originally stolen under the color of law. A piece of paper in the form of a corporate charter is a dead thing and cannot move a court or make a complaint or a claim. Only a living man or woman may do so. This is a fraud upon the people. When corporations were given the status of persons, this created the opportunity for criminals with bar cards to attack the people under the color of law. A piece of paper cannot be a harmed party, nor can it make a claim or make a contract. To imply that it can is ludicrous and insidious. The Erie Railroad decision attempted to hide the people's rights to remedy through a common law court of record. Common law courts of record were replaced with courts of equity, which are private for-profit contract law banking courts, evidenced by the gold fringe flags. This has been a windfall for the equity courts, who have imposed their private contracts onto the people for the purpose of pillaging. Abuse of discretion. Unilateral contracts with no benefits for the victims, abuse of authority, simulated legal process for public consumption, and so much more has been the result of this travesty of justice. The private corporate collection agencies acting as kangaroo courts have flourished under this criminal system. The lack of a candor of attorneys and clerks masquerading as judges is the norm. A sizable percentage of the holders of bar card union dues card lack contract character and consciousness. The people did not give enumerated power to be used to commit crimes against them. The people expected honest service and integrity from their employees. The people are sovereign without subjects and have a duty to resist tyranny and oppression executed under the color of law. The power which is derived cannot be greater than that which it derives from. When employees of corporations assume undelegated powers, it makes any unlawful action void. Power corrupts, and absolute power corrupts absolutely. In order for evil to prosper, good men must do nothing. Claimant is the sole heir and owner of the real property and its equity, generally known as 1239 Lynn Street, Bear Lake, Michigan. Legal description, Village of Bear Lake, and I'm not going to read the rest of his personal details, and all property to the west of the said land and building to the east edge of US 31 and butting up to the real property belonging to the owner of Richmond Drug Store, generally being known as, and there's another address there, land, and he's explaining his metes and bounds, ladies and gentlemen. He's putting down his metes and bounds, and he's going to do an acknowledgement and acceptance of this if he hasn't already, and do a quick claim deed and protect his property. He's going to have it in trust. Obviously, it's being held in the Sestake Trust, or the all capital name estate. All property that originally belonged to the claimant, now deceased parents, is now claimed by claimant. These properties originally belonged to the John and Karen Lecron. With their passing, these real properties became claimants by right of inheritance. These facts are on the public record at the Manistee County, Michigan courthouse in claimant's mother's will, as well as the fact that his claims remained unanswered a few years ago when original crimes were committed against claimant. Unrebutted claims stand as truth in commerce. Claimant's home of Michigan and the storage buildings for his antiques and other property generally known as, and it's an address, were destroyed under orders of a criminal entity, corporate fiction, and its board of directors masquerading as government under the color of law. The contents of these buildings is presumed to be lost forever and had significant value, both financial and otherwise. All of these real properties were acquired by claimant's father, John Kirk Lecron, and his wife, claimant's mother, Karen, via private contract. Upon their passing, a allodial title was passed on to claimant, who took possession of these properties for his exclusive use and benefit. Claimant spent in excess of $50,000 fixing up several of the buildings during his mother's final years, and one of the claimant's hourly employees nearly died from a fall while repairing the now demolished buildings originally known as, and it's an address, this real property only needed an electrical inspection as it had been completely restored outside and needed only minimal cosmetic work inside. There was absolutely no reason for it to have been demolished. Corporations are fictions with no status or standing, as they cannot make claims or, for that matter, do anything, as they are only pieces of paper with a corporate charter typed upon the paper in ink. To imply that corporation can move a court is ludicrous. The agents working for these de facto non-de jure governments, Latin for mind control, have used the ignorance of the people and corporations having the status of persons to undermine the people's absolute authority over these corporate criminal enterprises masquerading as legitimate government. Corporations and their agents have duties and responsibilities. Men and women have unalienable rights which are regularly violated with impunity for profit by employees of these corporations. Taxation is theft using compelled performance under threat and duress. This is extortion of thus good title cannot be passed on to third parties by fiction via their agents with bar cards, or men and women with costumes, badges, and guns acting as privateers. The basic of this perceived authority is the unconscionable contract made by Franklin Delano Roosevelt to foreign banking interests in 1933. His theft of the American people's gold and hypothecation of their property under the color of law to stand as surety for the corporation's debts was the crime of unlawful conversion. His co-conspirators were the governors and the state legislators at the time, who went along with the theft and the fraud perpetrated due to the bankruptcy of the United States Corporation. This bankruptcy was treated as a national emergency and still holds true today, over 86 years later. With the bankruptcy of the United States Corporation, Title 28 U.S.C. subsection 3002, section 15A, and the theft of the American people's gold and the voiding of contract based on this metal by Franklin Delano Roosevelt, unlawful executive order 6102 of April 5th, 1933. Americans have been forced to use Federal Reserve notes as legal tender, which are truly securities instruments, all right? They're promissory notes to pay. They're securities instruments. These are private foreign banking script with no intrinsic value and are not lawful money. Federal Reserve notes are only negotiable debt instruments with CUSIP numbers for use of the Federal Reserve Corporation members who have formed a criminal enterprise guilty of a multitude of RICO crimes. 84 Stat 922-3, aka 84 Stat 941, and Title 18 USC 1961 through 1968. Federal Reserve notes are a liability to the United States Corporation, which can be verified by going onto Title 12 USC Section 411. A debt cannot be used to pay a debt, and since the bankruptcy, it has become public policy that debts can only be discharged, not paid. The Federal Reserve members pay approximately 14 cents per Federal Reserve note, regardless of the denomination, which is supposed to be offset by the value of the assets that history has consistently proven the Federal Reserve banks do not have. This is evidenced by frequent bank bailouts, mortgage frauds, theft of contents of safety deposit boxes, inflation, which is a form of theft caused by a debasement of the currency, and of course the theft of the American people's gold and silver. A simple Google search using the word banking fraud will generate in excess of 851 million hits. The American people, who are the creditors of this behemoth of banking, have been victims as the Federal Reserve has abused its monopoly of the currency to exploit and steal from them for more than a century. The Federal Reserve fiat currency is manipulated regularly and used to purchase real assets with tangible value in exchange for their nearly worthless debt instruments. The monopoly of the Federal Reserve was authorized by only a small part of a board of directors Congress of 1913, when most of the other members were away on Christmas break. The bill would never have passed otherwise, as evidenced by Congressman Charles August Lindbergh Sr., who wrote the book Banking and Currency and the Money Trust. Just before it passed, Charles Lindbergh Jr. also brought articles of impeachment against several members of the Federal Reserve very shortly after the Federal Reserve Act was passed and signed into law on December 23, 1913 by President Woodrow Wilson. Public Law 63 43, Public Law 6343, Statute at Large, Chapter 6, 38 Stat 251. The only valid coin still in circulation with even a hint of legitimate history is a copper penny, which was among the first coins minted by the United States Mint. These coins were also debased as their size was significantly reduced in the late 1850s, just prior to the War of Northern Aggression, and then its composition changed to being copper-coated zinc in 1982. This is additional evidence of more theft as inflation continues to destroy the value of the currency due to the endless printing, credit creation, and bond purchases in order to continue to support this house of cards and the lie of the Federal Reserve and their debt instruments even to this day. Additionally, the value of commodities are also manipulated by these bankers. This complicates the procedure's ability to function due to the nature of this fraud and manipulation of various commodities and values. Banks are trading in places that they have no legitimate business interest in. The banks do it solely for profit and to protect the value of their debt instruments. For these criminals, banking enterprises, it is just business, while the people and honest producers of commodities suffer for it. There are no honest weights and measures anymore. There are only manipulated values of everything touched by this toxic currency, Federal Reserve notes. The administration process being performed in these private, for-profit kangaroo courts by attorneys using maritime admiralty, constructive contract, and racketeering fraud, hidden unilateral contracts with virtually no benefit to the victim, bartery clerks masquerading as judges, and the use of parents patents has been well documented by the claimant on the public record. Presumptions, parentis patria, hypothetication titles as such, delinquent taxpayer, and capitis diminuitio maximum, Latin for maximum loss of status, are other dirty tricks committed to continue this charade by converting the first creditor, we the people, into the debtor, i.e. the trustee of the trustees. This is a crime of conversion under the color of law using fraud. The people's equity is their sweat, blood, and life force stolen for the benefit of the employees of the various corporations masquerading as government and their banking masters. These corporations can be found on the Duns & Bradstreet website. Compelled performance under threat and duress is extortion, which is involuntary servitude, and therefore it is slavery, which is both immoral and unlawful. Just because something is currently considered legal to do does not make it lawful. Many Nazi war criminals discovered this truth after World War II when they were shot or hung for their war crimes. Corruption is an act done with an intent to give some advantage inconsistent with official duty and at the expense of the rights of others. This is prevalent in both the de facto governments and in these private contract equity courts who use the monopoly of the law and force to terrorize and enslave. Most people do not voluntarily consent to being stolen from. Neither do they knowingly consent to having their common law courts of record where their rights were guarded changed to maritime admiralty contract equity courts where their rights are violated. It is an open secret that people are being punished for contract violation that the people are not even aware of. The people were put into commerce and contract through fraud. See the Erie Railroad decision for that crime. Again, perpetrated by the criminal banker Franklin D. Roosevelt, who stacked the United States Supreme Court with his puppets when the original court would not go along with his plundering of the country. Law is simple concept to grasp. It is merely 3 words with a basis in peaceful coexistence. Those words are do no harm. To fail to know this universally recognized truth is gross negligence, which equates to fraud. Gross negligence and fraud, one and the same. Many bar card holding attorneys are guilty of gross negligence. Far too many bar members impose their private for-profit contract law on the people for their profit, which is unjust enrichment. The people have been sold legal services by members of this criminal monopoly. Power corrupts, and absolute power corrupts absolutely. These agents of the bank, i.e. bar members, a private union dues paying club, are the administrators for the United States bankruptcy. They work for the foreign bankers who have claimed ownership over the people and their property. Ladies and gentlemen, these bar members are in the House of Representatives, they're in Congress, they're in your local municipalities. They're in every facet and aspect of this. In order for this to work, their private monopoly needs to absolutely control everything, which absolutely corrupts everything. So even if, let's just say you're watching this evening and you happen to be a board member of a county, you have seen firsthand, because I attend these meetings, you have seen firsthand when 12 people sitting around a table cannot figure out what the heck is going on. What is the first thing you reach to? You reach to your lawyer, your prosecuting attorney. You reach to them because it's all securities, it's all bonds, it's all about monetizing instruments, it's all about funds, it's all commercial. And so you reach to the bar member in the room because he's licensed by the licensor as a licensee to conduct business, to medallion stamp bonds, to generate wealth within the community, to authorize certain things. And it's because we have given them so much power by allowing them to play in the background instead of taking control of the House, the Congress, the Senate. As good living men and women, we've allowed these people to use their trickery, leading us to believe they're more intelligent and more capable than we are of managing our own affairs. And we let it happen. We let it happen. But you can fix it, okay? And you have to do this on your own. It's an ascension of your own mind. You have to stand up. You have to tell them who you are and where you get your power from. This is the So the people had their gold and private property stolen and were made surety for the United States corporation debts in the bankruptcy of 1933. This is a most unconscionable contract done by the criminal banker Franklin D. Roosevelt, acting as president of the United States Corporation. That was the crime of unlawful conversion under the color of law. The governors and state legislators at that time also consented to this crime of high treason. The national emergency that followed appears to be the fraudulent foundation that bar attorneys are now using as justification to pillage and steal from the public trust, which is each and every one of our estates. As trustee and administrators using administrative process for the bankruptcy, many bar attorneys are using constructive contract and racketeering fraud as well as the color of law in private maritime admiralty tribunals where rights are trampled with impunity by union due card carrying private association bar members. The beneficiaries of the trust are regularly the victims of bartery in these kangaroo courts. People are finding it difficult to get honest service with unbiased judgments. Decisions constantly favor bar attorneys and de facto governments and their agents, while the people's wealth and life force is stolen through the use of extortion and fraud. If people cannot do these actions without getting put in prison, then neither can corporations and their agents. Moral turpitude is the norm in government and kangaroo courts, Star Chamber tribunals. According to an 1801 British Merchant Marine Handbook, bar attorneys are international shipping clerks, not lawyers. They are supposed to act as customs agents aboard ships or be employed in a customs house on the land. They are not learned in the law, only in policy and procedure of a private corporation's philosophy and policies for its employees and fellow club members. This is corporate feudalism using administrative process and the color of law. Attorneys use a foreign language called legalese to impose their will upon the people. This language, which sounds like English, requires a dictionary called the Black's Law Dictionary, of which there are numerous editions. The meaning of words frequently changes in these dictionaries to perpetuate the scam. Additionally, the words are actually just terms and are nothing like what their meaning is in common use by people in their daily lives. This is called the fraudulent conveyance of language. Truth is a defense to defamation to include slander, that which is spoken, and liable, that which is written or published. Since claimant, a living man with unalienable rights, is living in a faith-based society evidenced by public policy, it is his wish to take absolute title, aka title absolute, aka allodial title, to all land improvements with regards to this controversy. Claimant believes that no other living man or woman has a superior claim to his and instructs the trustee, the one in the black robe, to witness that the allodial title and absolute deed are now placed in claimant's name, not that of his corporate fiction person. If there is anyone that has come forward with superior claim filed under the pains and penalties of perjury, claimant instructs them to inform him of their facts, to dispute his facts and claims. Claimant intends to use this real property for his exclusive use and benefit and without any contracts or encumbrances. This is also known as fee simple or cession. The real property claimed by claimant is to be removed from all taxing agents of corporation, masquerading as de jure government, who are only de facto governments who have usurped the people's rights to a republican form of government. The real property and any future improvements on the land are to be considered private property of the claimant and his heirs and not subject to any jurisdiction, real or imagined. Claimant wishes that all rights, titles, and equity are passed to him with prejudice against all others. In closing, the state of Tennessee Corporate Charter Constitution, a contract with the people of Tennessee, which should also be noted and be relevant here in the land mass of Michigan, minds everyone in Article 1, Section 1 and 2, Declarations of Rights, Section 1, that all power is inherent in the people, and all free governments are found on their authority and instituted for their peace, safety, and happiness. For the advancement of those ends, they have at all times an unalienable and indefeasible right to alter, reform, or abolish the government in such matter as they may think proper. Section 2. The government being instituted for the common benefit, the doctrine of non-resistance against arbitrary power and oppression is absurd, slavish, and destructive of the good and happiness of mankind. The facts presented here are true to the best of the claimant's knowledge and belief, and are based on all available evidence, due diligence, years of exhaustive research, extensive peer preview, available public records, and the natural law concept of do no harm. Men and women have unalienable rights to property not owned by other men and women. Corporations and their agents only have duties and responsibilities as trustees, and they regularly abuse this position. These facts are filed by John, acting as the claimant under the pains and penalties of perjury. May peace and justice prevail against tyranny and corruption. And that's all. I hope this audio video does you some good. I found that to be extraordinarily enlightening, and for you guys that are just beginning, it's a wonderful place for you to start. Build a solid foundation off other people's research. John has put in 20, 30 years of research into this, and it's a great foundation for each and every one of you to really examine what's transpiring. So thanks for joining me. Really appreciate it. Thanks for all your contributions. Donating to the end of the tyranny. It really helps us continue to do what we're doing. And thank you for your time.